Good afternoon. Happy Thursday. My curiosity got the better of me, and I went on Pacer, and I found the district court opinion in the Cortes-Ramos versus Martin Morales. I'll put a copy of this on my Discord if anybody really wants it. I always use Recap, but it's a Chrome extension that automatically uploads it to Pacer. So this will be on, not Pacer, what they call it, Court Listener. So this will be on Court Listener too. So you can download it there if you don't want to come to my Discord. I can understand why people would want to come to my Discord. I, generally speaking, don't want to go to my Discord either. So the procedural posture of this is the district court had dismissed the case, the copyright claims of Cortes-Ramos with prejudice because he had filed them late. And he appealed, Cortes-Ramos appealed, and the district court, or the Court of Appeals, First Circuit Court of Appeals, said, wait, the district court can dismiss with prejudice, but they got to say why. And so we're going to remand this back to the district court to figure out whether or not you should dismiss this with prejudice or you should dismiss this without prejudice. With prejudice means that Cortes-Ramos would not be able to refile it. Without prejudice means he would be able to refile it. So the issue is that the plaintiff had filed a copyright lawsuit without having a valid registered copyright. And we'll go through the legal standard and analysis and the registration requirement, etc. And so there's like 3.5 pages or so, a little less than 3.5 pages. So turn on closed captioning and maybe YouTube will be able to capture all this. So part 2, legal standards and analysis, subsection A, leave to amend. Rule 15 of the Federal Rules of Civil Procedure provides that a party may amend its pleading once as a matter of course within 21 days after serving it or after service of a motion to dismiss. And then Federal Rules of Civil Procedure 15A1, capital A to B. Well, that was Rule 15A1, capital A to B. Rule 15 further provides that in all other cases, a party may amend its pleading only with the opposing party's written consent or with the court's leave, and that's Federal Rule of Civil Procedure 15A2. It is well known that Rule 15A the Rule 15A leave freely given standard is liberal. There was no quotes around that, so that's hard to read. However, it is not limitless. See Rife versus One West Bank, citing Foreman versus Davis. See also United States versus D'Agostino, or XRL D'Agostino versus EV3, citing O'Connell versus Hyatt Hotels of Puerto Rico. For example, pursuant to the Supreme Court, an amendment to the pleadings should not be allowed where there is, quote, undue delay, bad faith or dilatory motive on the part of the movant, repeated failure to cure deficiencies by amendments previously allowed, undue prejudice to the opposing party by virtue of allowance of the amendment, and futility of the amendment. And that is citing Foreman versus Davis. See also Averbeck versus Rival Manufacturing Company. Finally, it's worth noting that the grant or denial of an opportunity to amend is within the discretion of the district court. Again, citing Foreman versus Davis. It says Foreman versus Davis. I think it's supposed to be Foreman versus Davis, but even district courts make mistakes. And yes, I did have Taco Bell. I had 2, not 1, but 2 bean burritos with green sauce, no red sauce, and they were delicious. And not particularly low calorie. So the interesting thing about that subsection of the legal standard and analysis, the leave to amend, notice that pleadings should not be allowed where there is undue delay. And you're going to say to yourself, when did Chile file this? A long ass time ago. Undue delay. Bad faith or dilatory motive on the part of the movement. Well, I don't think I should have to go too far in detail to show the bad faith and dilatory motive on the part of Chile. Remember, this started off as a lawsuit for assault and battery, as well as defamation, I believe. Tortious interference with business, things like that. And all of a sudden it morphed into a copyright lawsuit. So, I mean, it should be fairly easy to prove bad faith or dilatory motive. Repeated failure to cure deficiencies by amendments previously allowed. The court has allowed, I think 4 so far. I think he did his one by right and then 3 others. So I think there's been 4 amendments that he's entitled as supplements. And the last one was supposed to, the very last one, YouTube had said, we're going to 12b6. And he's like, well, I'm going to just file an amended complaint. And they're like, okay, well, they moved the court. Hey, can we not file an answer or anything until he files his amended complaint? And the court's like, yeah. And then he doesn't file an amended complaint. He files a supplemental complaint. And so then they 12b6 it. So he's going to be like, oh, but it's a supplemental, this and that. I mean, it's all bad faith. And the fact that he doesn't see it doesn't mean the court won't see it. Now, that also doesn't mean the court won't give him extra do-overs, because courts tend to do that. What else? So he's had multiple failures to cure by amendments previously allowed. The undue prejudice to the opposing party by virtue of the allowance of the amendment, that's minimal. YouTube's just going to have to 12b6 him again. And the futility of the amendment. Can he actually plead a copyright infringement? Now, one of the defects was that he didn't allege in his complaint that he had a valid copyright, a registered copyright. But that was only one of the defects. I'm sure Google went over the rest of them, or at least most of them, but there were multiple other defects. So can he actually, is Chile capable of amending? Will the court think that Chile is capable of amending his complaint suitably to make it worthwhile to give him another chance of amending it? That's the question that the court is going to have to address. All right, now on to subsection B, Copyright Act's registration requirement. The Copyright Act of 1976 provides certain copyright protections to, quote, original works of authorship, end quote. To that end, the author gains certain, quote, exclusive rights, end quote, upon the work's creation. See 17 U.S.C. 106. See also Eldred versus Ashcroft. One of the protections afforded to authors is their prerogative to file a civil suit for infringement of his, quote, exclusive rights. See 17 U.S.C. section 501B. However, in order to pursue an infringement claim, generally an author has to comply with the requirements set in section 411A of the Copyright Act. Specifically, section 411 of the Copyright Act states that, quote, no civil action for infringement of the copyright in any United States work shall be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. That was 17 U.S.C. section 411. Recently, in Fourth Estate Public Benefits Corporation versus Wall Street Com, LLC, the Supreme Court had the opportunity to reiterate the registration requirement and furthermore clarify, quote, when, end quote, said registration occurred. To that end, the Supreme Court stated that, quote, outside of statutory exceptions not applicable here, Section 411A bars a copyright owner from suing for infringement until, and then, subquote, registration has been made, end subquote, end quote. Furthermore, in Fourth Estate, the Supreme Court explained that, quote, subquote, the registration has been made, end quote. Well, I don't know why they had a subquote in there. Registration has been made within the meaning of 17 U.S.C. 411A, not when an application for registration is filed, but when the register has registered a copyright after examining a properly filed application. The district court fucked up its quotations in there. Again, nobody's perfect. After the Supreme Court's decision in Fourth Estate, various district courts have faced requests, similar to plaintiff's request in the instant case, to amend complaints in order to satisfy the registration requirement of the Copyright Act. The court notes that a considerable amount of district courts have found that allowing such an amendment would run contrary to the Supreme Court's interpretation of Section 411A pursuant to the decision entered in Fourth Estate. Now, here is the collection of cases. This is all that YouTube was citing this case for. See, for example, Ambrosetti versus Oregon Catholic Press. Nina Rawls versus Paradise Artists. UAB Planner 5D versus Facebook. And citing specific language out of that one, stating a plaintiff cannot cure its failure to meet the preconditions set forth in 17 U.S.C. 411A by amending its pending complaint. Continuing on with the citations, May Larson Designs versus Want to Scrap LLC. Again, with some text cited. To adopt plaintiff's reasoning, the court would have to hold that the Fourth Estate allows a plaintiff to file a lawsuit before copyright registrations have been awarded, and to amend the pleadings after registration is obtained, so long as the effective date, i.e. the date of application, predates the filing of the lawsuit. The court cannot square this argument with the holding of Fourth Estate. Continuing on with the citations, Malibu Media LLC versus Doe. And then the quotation from that is, plaintiff's argument would make a meaningless formality out of Fourth Estate's requirement that an application be approved prior to filing suit. Were it correct, a plaintiff could file suit at any time, notwithstanding Section 411A's precondition, and simply update the complaint when registration finally occurred. And that's the end of the quotations, and we're back to what the court in this case is talking about, and this court says it agrees with said determinations. In the instant case, plaintiff filed a certificate of registration issued by the United States Copyright Office with regards to the works he submitted to the contest. The reference certificate reveals that the effective date of registration was March 1, 2017. That is almost a year after the complaint in the instant case was filed. If the court were to agree to petitioner's request to amend, it would validate the filing of a suit in violation of the requirements set in Section 411A. Therefore, the court denies petitioner's request for leave to amend, filed at docket numbers 104, 105, 107, and 116. As previously stated, the First Circuit remanded the instant case for the sole purpose of determining whether plaintiff should be awarded leave to amend the complaint in order for him to satisfy the, quote, registration requirement, end quote, of his only surviving claim under the Copyright Act. Since the court hereby denies the request for leave to amend, the plaintiff's Copyright Act claim is therefore dismissed without prejudice. And then there's a footnote there. It says, defendant requested for various reasons that said dismissal be made with prejudice. However, as the First Circuit stated, plaintiff, quote, could allege registration in a new action, end quote. So what does that tell us? That tells us that assuming the district court in Decastro versus Abrams doesn't just transfer venue to the Northern District of California, assuming that doesn't happen, the logical step that the district court in the First Circuit will take would be to dismiss it without prejudice, to allow Chile to refile it and properly allege registration of his copyright in the Northern District of California. I don't think Chili's going to be able to keep this in Massachusetts, at least not with Google on board, at least not as to Google. Whether or not it gets transferred for Abrams and Peter, I doubt that. So what I anticipate happening is I anticipate the easiest thing for the court to do is to dismiss the action as it relates to Google without prejudice, basically implying to Decastro that he's going to need to refile this against YouTube, Google, in the Northern District of California. My best guess. Anyway, the opinion, I will put it on my Discord, so if you want to have access to it, you can. Other than that, I know there has been pleadings going on in various cases, and I will most likely get to them on Sunday. There is a county fair on Saturday. I plan on going there and buying horribly overpriced animals to support kids in 4-H and Future Farmers of America, because that's the right thing to do. Anyway, thanks for watching and have a great day.